Are you going through a divorce and wondering who is going to pay for your children's college education? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how Connecticut divorce and custody law handles the payment of college expenses. Connecticut General Statutes Section 46B-56C is the law that allows courts to issue educational support orders in situations where parents are either divorcing or parents who have never been married are separating and determining custody in family court. The court is allowed to issue orders for contribution towards college if it determines that it is more likely than not that the parents would have contributed towards college had they remained an intact family. Doesn't mean that the parents will pay for all of college, just that they would have contributed some portion to college if they had not separated. Now, the maximum the court can order is the cost equivalent of 4 years of undergraduate tuition, room, board, books, etc. at the University of Connecticut. Doesn't mean your child has to attend the University of Connecticut. It just uses that benchmark cost as the maximum the court can order, unless the parents specifically waive that cap, in which case the court can issue orders above and beyond the cost of 4 years at UConn. It also does not necessarily mean that the court will order the parents to pay the cost of 4 years of UConn. That is simply the cap. So the court could order anywhere from $0 if they feel that the parents really can't afford the cost of college, or they can order up to that cap or anywhere in between. Now, to determine how much of that UConn cap is paid by the parents and the proportion that each parent will pay, the court will look at a number of factors. They will review the income and financial resources of both parents and the child. They'll look at the child's eligibility for financial aid or scholarships. They will look at the child's aptitude for college and the relationship the child has between each parent. And ultimately, the court will issue orders that it deems are fair and equitable in determining how much, if any, each parent will contribute towards college. Now, you may be thinking, my children are only 8 and 10 years old right now, so how can we be talking about college, which is years and years away? And that is a good instinct to have. Unless the children are just about to go to college, what the court will usually do is simply reserve jurisdiction for the court to determine at a later date who will pay for college and how much of a contribution will be made. So in order for the court to reserve jurisdiction, it simply has to make the determination that the parties would have contributed some portion of the college expenses had they remained an intact family. And what will happen from a practical standpoint is you and your spouse should do your best to try to reach an agreement as to who is going to pay for how much of college once it comes time for your kids to go to college. And if at that time you are unable to reach an agreement, then either one of you can bring the other one back to court and ask the court to make a determination as to who will pay for how much of college. Now, the court doesn't have to simply retain jurisdiction. They can enter specific orders as to who is going to pay for what portion of college. But again, that is usually only done when the children are about to go to school, or if it's done by agreement. Sometimes parents will just know well in advance that they want to pay a certain amount of college, or they may agree that they don't want the court to retain jurisdiction because they, for whatever reason, don't feel that they as parents should contribute towards the college education of their kids. Now, if you are at a point where you're determining with your spouse who is going to pay for how much of college because your child is about to enroll in school, I would encourage you to do your best to reach an agreement whenever possible. Judges' orders on these types of cases in particular are very unpredictable. Judges have all sorts of different values around who pays for college, whether or not parents should be paying for their children's college, or whether the children should be paying for their own college education. Judges at the end of the day are human beings, and on these particular issues, their orders can be very unpredictable. So I would recommend that you do your best to reach an agreement with your spouse if possible. So those are the basics on how the payment of college is dealt with in divorce and custody cases. As usual, if you have any additional questions, we would invite you to contact our office. And if you're looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.